Hello everyone, welcome to the webinar that we are going to have tomorrow in Ceca Abogados with my colleague Ana Gómez, his partner from the Labor Department, and the subject, the very hot subject that we are going to talk about is alternatives in Spain to confront coronavirus from a labor law perspective. Okay, so thank you everyone that has joined us in this beautiful Friday morning. And my colleague, as I said, Ana Gómez, is going to start with the webinar. The webinar is divided into two parts. The first one is going to be devoted to the measures that has been taken during the COVID-19. And after this explanation from Ana, we are going to answer the questions that had arrived in the meantime. And the second part will be devoted to those measures that can be taken after COVID-19, and it's going to be presented by me. So without more presentation and saying again, thank you to everyone, I pass the stone to my colleague Ana.
Thank you, Manu. Thank you, everybody, for attending the webinar. It's really a pleasure. I hope that you enjoy it. It's going to take roughly 20 minutes explanation by me, and I really wish that everybody is free to make questions, that you can write the questions. So after my speech, I will be very happy to answer them. Okay, so my part, as Manuel has told you, is going to be focused on what have happened for companies in Spain during the crisis of COVID-19. Okay, so as you probably know, in Spain, everything started mid-March when the government declared the state of alarm. That measure was very unusual. It is regulated in the Constitution of Spain, and principle what happened then was the paralysis and closure of many businesses in Spain immediately. And apart from that, of course, many other business that didn't have that order to close at that moment were frontally impacted because of the crisis and had a decrease on their activities. So what happened to everybody in the business then? Okay, for the companies that were in the list of activities closed by the government, the companies could take immediately measures with the help of the government. And I'm going to explain them briefly to you. The first and the priority measure taken by the government was the order to employers to put in place a remote working model. It's true that many companies had that model before, but many don't. So it was really a surprise to see how quickly and employees and employers made that adaptation, sent everybody home to work from home remotely. The measure of working from home is already in place since March 14 and is going to be in place till beginning of August by the government. This is compulsory whenever the employer can put the devices, okay, and can also pay for that. It's not obligatory when the company cannot afford it. So working from home has been one of the principal measures that has helped companies in Spain throughout the crisis to support the jobs. Okay, another important measure that was adopted by many employers at that time because of the closure of schools, universities, and for schools for children, was to adapt the working time of employees, giving them paid leaves or not paid leaves, unpaid leaves as well, to take care of children, stop working, okay, and adapt how they should recover that later. But the main and the principal measure that has been taken by companies in Spain during all this time is the ERTE, ERTE. This word refers to the measure of suspension or reduction of working hours of employees. So the company can make employees to be in a special leave for the time of the crisis without any salary and getting some unemployment benefit that I'm going to talk about later. Or either take the employees work partially for some hours per day, per week, per month, okay? So there were two possibilities, either suspension of the contract or reduction of working hours. But the ERTE, which, just to give you a rough idea, has been applied for more than 5 million employees in Spain so far, and more than 3 million employers in Spain. So it's been huge demand of ERTEs. This kind of measure was adopted by the Spanish government in order to prevent job redundancies. Okay, so it was very important to adapt something quicker, so companies could just go and ask for the ERTE in order to put the employees on this special leave or on this new work schedule, so the companies could save money on salaries and cost on social security, because depending on the kind of ERTE, the company would be allowed to reduce also the cost of social security contributions. Because in Spain, there are two kinds of ERTEs. I'm going to talk about them. There is one which is called force majeure, and this is mainly focused for the business that were suspended from activity immediately just after the state of alarm was declared by the government. So from March 14 till now. These type of industries are, of course, tourism, hotels, restaurants, schools, car repair stores, clinical, and many others. For those kind of business, which could say, I cannot work because the government prohibits me to work, they could ask for the ERTE force majeure. And this kind of ERTE allowed the company to stop paying Social Security, or at least reducing a lot of amount of money from Social Security, stop paying salaries or a lot of amount of salaries, and send the employees immediately home. The force majeure had a very quick process, so the company just needed to ask for it to the labor authority and present just a very short list of documents for it. Didn't need any consultation at all, and the process lasted just 5 days, so it was a very short process, as you see. So many companies in Spain immediately claimed for that measure. It was good that the government reacted correctly, and immediately the government, the labor authority, gave those ERTE force majeure to so many companies at that time, but there were others that the ERTE force majeure were denied. So what happened then? What were the possibilities for companies that didn't fit in the characteristic of an ERTE force majeure? For all of them, there were another possibility to ask for an ERTE. This is the ERTE for economic productive reasons, what we call ETOP. ERTE for ETOP reasons, okay? This is another kind of ERTE with a different process, different deadlines, but also very helpful for companies. So, during this crisis, many employers have also gone to this type of ERTE. It is important to tell that this kind of ERTE requires consultation with the workers. When companies in Spain didn't have any workers' council, consultation should be carried out with the unions. And this type of consultation has gone smoothly, I must say. So many companies in the end have reached Indian agreements with the unions or with the workers' council or even with the employees themselves, because if the unions didn't have the opportunity to consult, the law established a mechanism where the proper staff could elect among them a commission of 3 of them to negotiate with the management for the ERTE. ERTE has not the advantage to save money on social security contributions, but as the other type of ERTE, force majeure, they both acknowledge and recognize to the employees the unemployment benefit automatically, and I'm going to explain what was the amount of unemployment the employee could get. This amount of money is not obviously a lot, but it's a great help because it's 70% of the amount of pensionable salary. In Spain, not all the salary goes to the social security contribution every month, but it's capped. And based on the salary on which the company contributes to the social security, the unemployment benefit is calculated on. So it's 70% of that amount of money that the company declares every month to the social security to pay the social taxes. And besides that, the unemployment authority also pays a limit amount. So in any case, an employee on an ERTE couldn't be paid more than roughly 1,200 euro, depending on the average of children they have, 1 or 2 or more. So this is to give you an idea. An employee who goes on ERTE and the company doesn't pay any money to them because they are not obliged to, the employee will get from the state around 1,100, 2,200 euro gross per month from the state as an employment. Okay, because of that, normally during the consultation period, employers have agreed with the workers to pay a little more during the ERTE. Okay, so if an employee is on ERTE, during the time of the ERTE, he or she will get just that from the state, probably something more from the company, and the employee remains on Social Security, okay? If it's an ERTE for force majeure, the company is free to pay any Social Security or just a little, depending on the size of the company. But if it's an ERTE for ETOP reasons, the company should remain paying the same Social Security contributions every month for everybody. Okay. It is also important to tell you that ERTE has been the most important measure, and it is still. We are under discussions at the moment in Spain when is the last moment to end the ERTE so people come back to work. Of course, this is linked to the activity, but the government, because of the amount of public aids to companies because of ERTE, wants to short the period of ERTE. So at that moment, now, we don't really have a clear idea how long it could last an ERTE for force majeure. We think it could last until the end of June, but we are not sure so far. The government said that the state of alarm will end at the 24th of May. So we will see what happens, because the government has announced new measures for companies that are under an ERTE for force majeure. The companies that have chosen an ERTE for ETOP reasons have a longer period of time to remain on ERTE, because during the consultation period, both parties have agreed what is the duration of the ERTE. Okay, so it's been quite complicated for companies in Spain to apply for the ERTEs because they were new, and the process has been really created ad hoc for the situation. But it's true that has helped many employees in Spain not losing their jobs. So what are in the company's minds right now? Worries about how they can recover the activity, how they can restart again their business and take back employees from the ERTE again on the business. And this is going to be, we are seeing this really complicated so far for employers. What else? Because there's a lot of things and I don't want to bother you so much with theory. I want to let you ask much better. So just briefly, let me tell you about holidays. Many employees wanted to, instead of going to ERTE, to manage with the employees if they could take during the crisis their holidays or not. Some employees did it directly without any employee's consent, and that was wrong. Because in Spain, in order to fix holidays, you need the employee's consent. So without an agreement with the employee or with the Workers' Council, the company could not impose the days of holidays, okay? And to end my presentation, I would like to briefly refer to another extraordinary measure that was taken by the government at the end of March, beginning of April, that was to impose employers to give a special paid leave to employees for just 8 working days, so that employees were sent home for doing no work at all, but the employees need to recover those hours of the 8 days, as I say, till the end of the year. In order to recover that amount of hours, which is a lot, the law has foreseen a consultation period with the Workers' Council or unions. And it is important to make that consultation properly, because otherwise the employer will not be entitled to recover that amount of hours from the employees. Okay. I have been very happy to give you my explanation. I don't know if there's any questions at all. Probably yes, because this is a really tricky matter. So I'm going to check. Yes, I'm happy to hear that there are a lot of questions. Okay, we have one from Marta Roman. You mentioned that working from home, it is compulsory, but as far as I've heard in the it's just a recommendation. Okay, Marta. At the very beginning, we thought that, but later on, we've seen that the order was rather mandatory, because the purpose of the measure was to avoid any other measure more harmful to employees. Okay, so whenever it's possible to send employees home for work, that has to be the priority of the company. Of course, there are exceptions, and if the company cannot afford it, or is not possible to implant this type of working model in the company or in the business, of course, the employer is not obliged to, okay? I don't know if I have answered your question. I hope so. If not, Marta, we can be in touch. Let's see if there are any others. 2 months from the end of the state of alarm. That's correct. That's correct. So that is June and July. So it will take us until the end of July to implant remote work. There is another question. What is the maximum duration of an ETOP ERTE? Is it possible to start it after the end of the state of alarm? Or the conditions would change? Okay, this is a very clever questions. Why? Because the ETOP ERTE is flexible. Parties could negotiate during the consultation period the duration, the length of the ERTE. It's true that the ERTE for ETOP reasons can be extended after the state of alarm in Spain. As I said, it will last till the 24th of May, okay? And also, employers in Spain are going to be allowed to negotiate ETOP ERTEs after that, okay? Another question from Gerardo González, thank you very much. And it refers to an ERTE for force majeure. Is it possible our work is progressive disaffection once time the lockdown or force majeure cause it finished? Yes, let me answer this question. Of course, it's possible that once the activity returns not to normal, but to the new normality, employers could call the employees on ERTE to be back on the company, to return to work, and these calls done progressively, gradually, depending on the amount of increase of workload. This is really important, and this gives a relief to many employers at the moment. There is another question. What can the company do if the force majeure ends, for example, end of May, but the economical activity doesn't justify the presence of the employees? Okay, so in order to answer this very interesting question, an employer that at the moment has an ERTE for force majeure, and the force majeure ERTE will stop, but the company has not enough work for everybody, it's possible to negotiate, okay, an ERTE for ETOP reasons. Okay, so there is a relief, a little, for these employers, and obviously one ERTE for force majeure can be substituted for an ERTE for ETOP reasons, okay, with immediate effects. There is another question from Rafael Canales. Thank you very much. Due to the expected progressive back to business for many companies, would it be possible to remove ERTEs partially? I mean, just for part. But I think, Rafael, I have already answered it. Yes, you can remove from the ERTE just a part of your employees, and even it's possible, and this is very interesting for employers to know, that you can take back employees from ERTE on part-time jobs. Okay, so you don't need to keep the whole working day, and you can just simply let them start to work on a part-time basis. I hope I've answered your questions. There is another question. Hello, during ETOP, can you please confirm if we can do employment termination? Okay, I haven't mentioned this because I would be very happy to let Manuel, my colleague, to answer it. And this is really a very important matter at the moment. According to the law, and this is very, very extreme and new, the company cannot make people redundant at the moment, okay? Only it is allowed on very specific reasons, and these reasons, I'm afraid, just refers to gross misconduct. So I'm afraid that you cannot make people redundant at the moment in Spain during the crisis we are living. There is another question from Jigit. I'm so happy to see clients. Hello, Jigit. I understand that it's not compulsory, but highly suggested that the employee should work at home until end of July. Is it my understanding correct? Yes, correct, Jigit. Your understanding is totally correct. So it is highly recommended, but also, as I said, it's rather mandatory than recommended. Okay, so employers that has allowed employees work remotely during this period should prolong that model until the end of July. Another question from Digit. If the employee refuses ERTE for ETOP, for example, duration, the reason of ERTE, ETOP, or additional payment by company, could company force to implement ERTE, ETOP? Yes, yes, you can. The decision to implement an ERTE for ETOP reasons is of the company. It's true that the company must negotiate it with the workers, okay, but the final decision is of the company. If the employees are not happy with that decision, or the unions, they are allowed to challenge it in court, okay? So we also expect, when everything is back to normal, especially the court's activity, that we are going to face probably a high amount of cases in court, because they are not happy with that, okay? We will see. There's another question from Fina. How do you think the return to the office will be for those companies who have implemented working since the beginning of the state? This is really, really interesting, Fina. Thank you so much for raising it. Why is that? Because it's true that we now face that working from home has really worked. So it's going to be hard for employers when everything is go to the new normality to deny this type of work to employees on the basis of business reasons, okay? So I would say to the audience, I think this is going to be a new topic on the discussions between employees and employers, but we have to see what's going on, what happened, okay? There is another question. Hi, Anna, I've been distracted. Can an employer still make redundancies without first considering ERTE? This is, I'm afraid, not possible. And we are now under discussions with the government to make a date, a final date of prohibit or let's say period during which the companies cannot make people redundant. Okay, so far the announcement from the government is that during this year companies will not be allowed to make people redundant. Okay, so it's going to be very difficult. It's true that, of course, if the dismissal is not based on the COVID-19, the employer is free to dismiss, okay? So, of course, following the law. But it's going to be very difficult and hard for employers to connect the reason of dismissals to another reason that is not COVID, okay? We will see. There is another question from Mark. Hi, Mark. Hello. Not sure if within the scope of this webinar how to deal with variable remuneration. Objectives set beginning of the year will not be achievable. Do the correct candidate claim for change of objective? Okay, Mark is raising another issue, which I think is very interesting, probably for Manu, my colleague. But to answer it, I think yes, I think employees may start discussing the part of the variable when all the circumstances change dramatically from one day to another. So I think, Mark, that of course this could be a topic now. There is a question from Catherine. Thank you, Catherine. Can a company implement ETOP for some workers, or does it have to be implemented for everybody? Really, this is easy to understand, easy to respond, Catherine. The ETOP, an ERTE for ETOP reasons do not need to cover everybody. So just need to cover the employees that do not have work, okay? And finally, there is one other question from 𝘾𝙤𝙚𝙚𝙚. Can we reduce the salary of the employee before the end of the ERTE and raise it once if the economic situation improves? This other decision of reducing salary, which is very interesting now at the moment, I'm afraid, is different from ERTE. So, of course, during an ERTE, the employer could take this measure, but let's be honest, it has to be consulted with the Workers' Council, okay? So you need, of course, to negotiate and in the end take a decision with agreement or not, but before with a prior consultation period. So I think this is my part. I'm being very, very happy to be with you, everybody. And now I pass my turn to Manuel and hope that you enjoy it. Thank you.
Thank you very much, Anna. It was a great presentation. You have left the bar very high, but I'm going to try to do my best. What Anna has presented has been mainly the measures that has been taken by companies during the crisis. As you have seen, is mainly the ERTE's force majeure and ETOP grounds. And the second part of the presentation is going to be about what measures can be taken in the post-COVID-19 era, okay? Just to have some context, the government of Spain has approved the escalation plan. Okay, this word, the escalation, I don't know if in other jurisdictions you are using it, but it's a very new one. And in fact, it's not in our Spanish dictionary. It's going to be included and is based on some phases that I assume that in the rest of the countries must be more or less the same. So on one hand, what we have from a practical perspective is that in each one of those phases, you can open or not your business, depending on some objective aspects, such as the distance between tables, if you have a restaurant, or for example, the disponibility in the hospitals of beds, etc. Okay. But from a labor perspective, what we want to analyze is what can I do in my company in this post-COVID-19 era. Okay, so I think that we have here three typologies of companies. The first one is the company that has survived to the COVID-19 without any special measure. For example, I'm thinking on Amazon, or I'm thinking on a distribution company, DHL, for example, that has been working more or less normally, and they have not taken any measure. The second one is a company that has applied an ERTE force majeure mainly, or maybe an ERTE ETOP. And the third one is a company that probably is not going to survive and we will have to apply a collective dismissal. Okay, it's not within this webinar, but I can make some reference to this part if you want. So the first thing is the slide that I'm now presenting, and we have 4 points. The first one is the transformation of an ERTE of force majeure into an ERTE ETOP. The second one is an ERTE ETOP ex novo. Okay, do you know if this is a Latin expression? The substantial change in working conditions, we are going to use MSCT, but I prefer to use substantial change. It's easier for me, at least, and geographic mobility. Okay, so just imagine that we have business, I don't know, Los Pollos Hermanos. I don't know if anyone has bought something legal in Los Pollos Hermanos, but we have this business, and we have applied an ERTE of force majeure for our business. Okay, so as Ana has perfectly explained, now our employees are at home, they are receiving their unemployment benefit, and we have a reduction of the 70% in our social security contribution. Now in Spain, the state of alert has been approved by our parliament until May 25, but probably it will continue until June 15. But the government has announced that they have closed an agreement with all the social representatives, both from the unions, excuse me, and from the business. Okay, and they will probably extend the effect of the ERTE force majeure FM, like the radio. Okay, this ERTE FM until June 13. Okay, so until June 30, the ERTE FM will apply with no connection or not linked to the state of alert. So the first thing is that if we have an ERTE FM, it's important to be negotiating a new ERTE ETOP, okay, because after June 29, we are not going to have anything. Okay, in other words, if we have this restaurant and we have now an ERTE FM on 29 June 2020, okay, we will have to open the restaurant as usual, okay, and our employees will be included in their normal payroll and 100% of their activity percentage. So if we want to be to have an alternative on this date, we have to have negotiated our ERTE ETOP with the unions and the workers' representative. Okay, because the main difference, at least in my opinion, between both kinds of ERTE is that the ERTE force majeure is not linked to any negotiation, and the ERTE ETOP is linked necessarily to a negotiation. The second one is the ERTE ETOP ex novo. Okay, this is in the first typology of companies, the one Amazon, for example, that has survived, but they are assuming, or they have some analysis that reveals that they're going to lose part of their business in the second semester. Okay, for example, I don't know, imagine that 𝘾𝙤𝙤𝙚 has prepared an analysis for Amazon Spain, is saying or stating that in the second semester of 2020, probably they are going to lose 30% of their sellings, okay, of the sales. So in this case, this ERTE top ex novo is going to be based on productive grounds. Okay, so if the market is not asking, is not demanding my product, I can apply a new ERTE top. So the second option is, the first one was to transformate my ERTE FM to an ERTE top. Something very important, there is no mechanism in the law to transform both. Okay, so I'm saying transformation just to help you to understand, but in fact, it's not a transformation. Okay, it's not a change of the name, but with the same information. Okay, but a new complete negotiation on ERTE. So the second one is to promote this ERTE top ex novo. Okay, and the third one is a substantial change in the working conditions. Okay, there's something very important I want to explain here, and it's the fraud of law. Okay, I assume that in any jurisdiction there is this legal figure, the fraud of law, that is to use a legal figure for something that was not the intention of the legislature. Okay, why I'm explaining this, and I have said this in many webinars, because if we want to reduce the working hours of our employees, and as a consequence of this, to reduce their salary, okay, the way is the ERTE. Okay, if we only want to reduce the salary of the employees, okay, if someone is successful with this, please call me. Okay, but if some company wants only to reduce the salary of the employees but maintain the working time, the way is the substantial change in the working conditions. So we can use this MSCT, okay, that you see in the presentation, to reduce the salary, for example, to change some conditions. Imagine that you have a pension plan in the company. Okay, so through this mechanism that is in Article 41 of the Workers' Statute, you can, for example, suspend, okay, the payment to the pension plan. So there are many alternatives. This is where I think that we have we give you the added value, and is giving you another ideas. Okay, because now if you go to Google, okay, you will read only about ERTEs or EREs. Okay, the ERE, the collective dismissal, and you will say, okay, in Spain, so I only can dismiss people, or I only can suspend the contracts. No. Okay, for example, you can use the substantial change in the working conditions, and you can stop paying the pension plan. For example, you can change the salary condition of the employees, etc. Of course, you are going to need a valid ground. Okay, no one is going, and the law does not prevail, or does not allow you to change the salary conditions unilaterally. Okay, and with no reason. But if you have a valid reason, you can play with another instruments that you have within your company. For example, this pension plan. Another thing that you can do, but now people is at home, so it's not going to be successful, is the geographic mobility. But for example, yesterday another webinar we were talking about, for example, you can think of garden leave. Okay, there is in Spain, I assume in many other countries, there is a figure called excedencia, okay, by which the employee asks the company, or asks to leave the company, and the company pays an amount of money. This is something that is not legal or illegal. In my opinion, is more illegal. Okay, it's in some middle is like a 13 figure, but we could use it. So my main message here, and we have only 10 minutes, and I want to answer questions, is that you have more alternatives, but only the ERE and the ERTE. Okay, so I don't use the PowerPoint. You have many information in the PowerPoint. I prefer just to explain it. Okay, but in this slide you have more information. The ERTE top ex novo, okay, with the grounds that have been explained in the first part. Here you have the substantial change in the working conditions. It's very important, and this is why we have highlighted it in the presentation, that the reduction of the working day of the workers to a maximum of 70%. Okay, if you want, you need more information, you have our emails at the end of the presentation, and please feel free to send us an email. We'll be very happy to answer you. Okay, so don't miss our emails. In fact, we are receiving many emails from the webinars. We are answering them, and it has been a great way, a great path, okay, to have a communication with you. Geographic mobility, you have everything in this presentation. Okay, so I'm going to see which questions do we have here. Okay, we have a first one from 𝘾𝙤𝙚𝙚. Oh no, this was answered, okay, by Anna. We have another one. It says, if in an ERTE ETOP with a reduction of working hours, workers work longer than established, what would the sanction, I guess, for both employer and employee, as you know, if there are been any labor inspection? Okay, this question, thank you very much for the question. Opens a very important part. And if you want, I can talk about it, and it's the sanctions, okay, from the labor inspection. As you know, here in Spain, we have a labor inspection. Okay, it's excuse me. Okay, excuse me, I've lost. Okay, we have a labor inspection, and both the activity of the working inspection and the sanctions, okay, has been changed in order to prevent companies from applying ERTES FM, okay, mainly ERTES FM in a fraud of law. Okay, so with a reduction of working hours, if the workers or employees, is the questions, work longer than established, it says what would be the sanction. Okay, it is a gross fault. Again, the sanction could be up to 6,250 euros. Okay, but we don't have a special, okay, or we don't have new types of sanctions, okay, in the context of COVID, but this could be a normal sanction that is especially established in the LISOs, okay. I'm going to say this in Spanish if you want to check in Google or in the BOE, Ley de Infracciones y Sanciones en el Orden Social, okay. Peter, we have another question. Thank you very much, Peter. He says, could the company reduce the salary, and how intensive could be that reduction? Okay, it's a good question, Peter. The first answer is yes. Of course, you can reduce the salary, and you have two ways. The first one is with a mutual agreement with the employees. Okay, many companies are doing this. If you have the agreement with your employee or with your employees, you don't have to follow any special procedure. Okay, and you don't have to do anything. You only reach the agreement, and you have to build a good agreement that I assume that you will use employees. Okay, so this agreement is a good one. The second question is, if you want to reduce, I assume that you want to reduce the salary of your employees, but they are not saying yes, Peter, they don't want you to reduce their salary. That is something very natural. You will have to follow the proceeding established in Article 41 of the Workers' Statute, okay, for the substantial modification of the working conditions. So you need a valid ground. You have, you know, I don't know, I'm going just to recall that we have 4 type of grounds: economical, technical, organizational, or linked to production. It was the one that I explained, okay, when you have a reduction on the products or on your sellings. So in this case, if you only are going to reduce the salary to 1 employee, to 2 or to 3, if you don't reach the thresholds established in Article 51 of the Workers' Statute, that are 10 employees if your company is 100 or under 100 employees, 10% of the employees if you are between 100 and 300, or 30 employees if your workforce is more than 300 employees. Okay, so in this case, you will have to promote a collective proceeding, okay, and a negotiation with the workers' representatives, and you have to reach an agreement with them or not. This is something very important, Peter. If you don't reach an agreement with the workers' representative, this does not mean that you cannot apply this salary reduction. What will happen is that the employees are going to file a claim against the company, are going to sue the company, stating that the ground is not valid and therefore they didn't sign this agreement. And it's going to be a judge, okay, in the social jurisdiction, the one that is going to analyze the case and say, yes, there is a valid ground to reduce the salary or not, there is not. Okay. Okay, we have more questions. They say, can we oblige employees to return to work in the office? Okay, one important part of this de-escalate plan. The question is from Mar, and one very important part of this question is that now in the de-escalate plan we have two parts. The first one is, can the employees go back to the office? Yes. Okay. In fact, the government has never said that you cannot go to your work. This is something very important. If you have a document from your company stating that you work and that you have to go to the office, you can go to the office. Okay, there is no limitation. And the second question is if we can oblige the employees to return to work. Here is, for example, yesterday in the radio, I was listening a program, and a soccer player was saying that he's very afraid and he cannot go outside of his house. Okay, I think this is a case of I don't remember now the name of the illness, agoraphobia. Okay, so he said that he's kind of agoraphobic, that he's completely scared about the virus and he doesn't want to go to the office. So if he's allowed, and he's always allowed to go to the office, and he says, no, I don't want to go back to my office, we have two scenarios. If he's working from home and he's fulfilling all his duties, you cannot do anything in principle, and the wise thing here is to wait during a transition period. Okay, but if he's not working at home and he's refusing to go back to the office, okay, in this case you have a valid case for dismissal. Okay, because he's not going to the office and he has left unattended his activities or his duties. Okay, the second one is from Bartholomew. Are there any restrictions for elderly employees or disabled employees? This is very linked to the previous question, and here is very important in everything that you are going to do related to come back to the employees to the office to count with your prevención de riesgos laborales, okay, with your health and safety providers. Okay, in every company, depending on the size of the company, you have an internal or external PRL team. Okay, so always ask them, because you can have any problem with these disabled employees or elderly. Okay, so always put them in the team. Alice says, what could be the risks if the company makes a restructuring redundancy plan after the summer? Okay, this is very, very important. Anna has told you and has explained that now we have an employment guarantee by which all the employees that have been included in an ERTE-FM, force majeure, cannot be dismissed in the 6 months after the end, okay, of the ERTE-FM. So, in one word, and now we have a criterion from the General Direction of Employment here in Spain that says that this is something nominal, okay? So this is not a guarantee to maintain the employment level for 6 months. If you had 5 employees now at December 31, you have 5 employees. No, you have to protect and you have to respect the employment of those employees that were with names and surnames were included in the ERTE from the very beginning. Okay, so this is one point. The second one is that there is a connection, and it's very important, between ERTE and collective dismissal. Okay, you cannot promote in principle a collective dismissal with the same grounds that you used for the ERTE FM. Okay, because here there could be another fraud of law, as I told before, because you the ERTE is foreseen for a conjunctural measure, okay, something that is going to be transitory, and the collective dismissal is definitive. Okay, so always ask to a lawyer here in Spain. Always ask for legal advice regarding the impact that the previous ERTE could have on a collective dismissal. Okay, so I think that we don't have. Okay, yes, I have more questions. Sandra, oof, I'm not going to have time, I think, because we only have 1 minute. I'm going to try to answer very fast. Sandra Meyers, it is possible to dismiss an employee because he is part of a union? No, okay, he's more protected because he's part of a union. Gerardo González, Gerardo, it's a very long one, and hi Gerardo, thank you for your question because I know him. Send me an email if you want and I can answer, okay? Francesco Conti, is it authorized the company to check corporal temperature for their employees? This is a very important question now. It's not regulated, but I know that they are regulating it. Okay, so probably we'll have news in this respect. So Francisco, please send me an email with your email, and we will include you in the bulletins that we are sending with all the legal questions. Okay, so you will be perfectly updated about this. Faina Perez, Faina, now I will call you by phone. Okay, Faina is a good friend and a good client. Thank you for your question, but we don't have more time. I will call you now. And the last one, Rosa, if the company is not under neither an ERTE nor an ETOP, can the company reduce the number of employees? Yes, you can reduce the number of employees, okay, through individual dismissals if you don't reach these thresholds that I explained in a period of 90 days. For example, if your company, if the workforce of your company is 80, the threshold is 10 employees. Okay, so if in a period of 90 days you dismiss 7 people, okay, you are under the threshold, so you don't have to promote the collective dismissal. Okay, so these thresholds, you can find them in Article 51 of the Workers' Statute. Okay, so this was the last question. I am very, very happy. This was our first webinar in English in the law firm. I think that was very, very nice. Thank you very much to everyone. Thank you, Anna, for your great presentation. And if anyone wants to send a question or anything, okay, here in the presentation you have. Let me just share the good one. Is this one okay? Okay, here you have our emails. Okay, I'm leaving this for 1 or 2 minutes, so we'll be more than happy to receive your emails. And again, thank you very much to everyone, and good luck and have a great weekend.
Bye.